Hello, beautiful people. Welcome back. In the past, we've spoken about the Fourth Amendment requirement of a search and seizure. And the patron was spoken about probable cause being a very low standard of evidence spoken of in the Fourth Amendment. Yes, probable cause, that term probable cause, is a standard of evidence to which the one purporting a claim against you has a higher probability of their claim to suffice against yours. The probable cause standard benefits the claimant rather than one to which the finger is being pointed at. So we went over the probable cause, we went over the offshoot of probable cause, which is stop and frisk or a Terry stop. And on Patreon page, you've shown the list of states that have Terry stop incorporated into specific language of certain state legislature before it was statutized. The question that ought to come to your mind is, even if they create this loophole for the purpose of creating an investigation, which will lead to a crime being found out, which will now create a warrant, which will trigger a probable cause. If they've created that type of loophole for themselves without first needing a warrant, whereby they can just do a Terry stop based on a fixed prerequisite of a Terry stop, which is brief, it has to be for the purpose of finding out that a weapon exists. Literally, it's straight to finding out weapon. It must be brief, it must be based on the outer layer of clothing, and it must not be intrusive. If that's the loophole to the probable cause, then let's rewind a little bit before all that action even begins to take place. 9 out of 10 times where the presence of any municipal armed men or women will be present at a certain location, it is most likely because your own fellow everyday man or woman snitched on you. It is because someone, because of their prerogative, how they felt that day, probably because their wife didn't suck their dick good enough, or their boss made them feel like a slave, or their husband yelled at them, or they feel like they failed as a mother, or whatever issue people deal with in their everyday life. Or they just don't have enough money to pay their rent. They take their anger out on someone. You'd be surprised by how much of a vicarious liability everyday man or woman is to their own fellow everyday man or woman. The issue of this world is created by us and us alone. Everything else is perfect. Therefore, 9 out of 10 occasions where municipal armed men or women are present before they even begin to act arbitrarily towards you, whether or not they know the law or the intricacies beyond what they've been conditioned within the culture of their environment to do, which is treat people anyway because most of them don't know their rights anyway, which they're not necessarily wrong on that end. But does that arbitrary act of treating people anyhow just because they don't know their right, is that right? Well, it's up to you to make that determination based on how competent you are. But before all that action takes place, something usually triggers these people's presence. They just don't magically pop up. Now, in certain circumstances, they survey certain areas, which that shouldn't even be occurring. But the people are so far asleep that they don't know that's unconstitutional. But then again, there are other case laws that says there's no reasonable expectation of privacy in a public area. That's another issue. But nonetheless, they survey people in certain areas through cameras, surveillance, for the purpose of basically creating their own probable cause. All that is another issue. The main issue we're going to speak of here is the situation where someone is quick to dial 911 and say, hey, something is going on over here. Come check it out. What if they come based on that premise? What is the standard to that as it relates to search and seizure? If someone gave a tip, an anonymous tip, or a caller said, hey, something is going on, come see what's going on, come be part of it. Because, you know, when I was a child, I was told the cops are here to save us all. So always dial 911, kids, okay? You little baby goats, just dial 911 if you see anything wrong. So people grow up in big bodies and they still carry that little state of mind. They call 911. Some people don't even care. They just do it because, well, misery loves company. And that's usually the applicable circumstance for most people, where the presence of these people is based solely on someone summoning them. Now let's relate that to them just searching and seizing someone, because they said, well, someone called, so now we're going to search and seize you. This case law is very simple and very self-explanatory. It's Florida versus the letter J, the letter L. Case number 98-1993. Florida Supreme Court. There's a citation. Facts of the case. On October 13, 1995, Miami-Dade police received an anonymous tip that a black male wearing a plaid shirt was standing near a bus stop carrying a gun. This is just what someone is telling them, right? And that was pleaded into the complaint and the supporting affidavit called the police report. So those allegations are accepted and thus are transitioned into the subsequent documents in the appeals court. But they're stating it as a fact, meaning these are just the things that we have available. On October 13, 1995, Miami-Dade police received an anonymous tip that a black male wearing a plaid shirt was standing near a bus stop carrying a gun. That's the premise. Someone called. They said, hey, I see someone who is black, who is male, who is wearing a certain type of shirt and is carrying a firearm. The two officers who responded found 3 black males, one of which, J.L., is a 15-year-old, was wearing a plaid shirt. After frisking him, aka Terry stop, aka investigatory stop, aka stop and frisk, aka the circumvention of probable cause based on res judicata, because most people have been asleep about their rights. The officers did find a firearm. J.L. was charged with carrying a concealed weapon without a license. At trial, he moved to suppress the gun as evidence, arguing that the frisking performed by the officers was illegal under the Fourth Amendment. Trial court granted the motion, but was reversed by the immediate appellate court. The Florida Supreme Court overruled the appellate court and suppressed the evidence. Just as a side note, they're basically giving you the hierarchies that a trial court exists, and then there's an appellate court to see the trial court's decision where you can escalate the situation. Even if the appellate courts make a certain decision that's not favorable to you, you can move it to the Supreme Court level. And let's take it a step further. Even if you take to the Supreme Court level on a state level, the state has a Supreme Court and the federal has a Supreme Court. And the Supreme Court in the state does something that's not favorable to you, so long as you evoke a federal jurisdiction, aka a regional jurisdiction, aka the United States Constitution, you can always escalate it further beyond the state Supreme Court to the United States Supreme Court, the United States being a treaty that each state is a part of. So you can always appropriately escalate it even the Supreme Court, even if the Supreme Court of the state makes a decision is favorable to you, just as a side note. So the premise is someone called and said, hey, I see this person who I think looks this way and they're carrying something on them. Come check it out, okay? So the 2 armed men came in. They stopped and frisked them. And they did find the firearm. Why? Under the premise that someone called and gave them a tip. Now, is that lawful? The trial court said yes, which is the immediate venue to which they sued this 15-year-old. Of course, whenever they do anything, they have to give it a cloud of legality by literally suing people. Traffic ticket, they issue a bond, they have to give it a cloud of legality by suing you. Summons, show up for a traffic ticket. If they say you did this, whether it's misdemeanor or felony, they have to give it a cloud of legality by suing you. They say show up. We have this information of belief based on what this cop said in his police report. Now we're suing you. In some case, we'll just do an indictment based on the secrecy of the grand jury in the state, and then issue a warrant for you as well. You're being sued. That location where you usually are initially sued is called a trial court, in case it's not clear at this point. And then there's another step where you can escalate it called the appellate court. The appellate court usually hears the decision of the trial court if you want to escalate it in a manner whereby you realize it does not favor you, but it ought to have. so long as you preserve the substantive evidence based on this constitution, aka constitutional error, on the record, because the appellate court cannot enter new evidence beyond what was already introduced in a trial court. And then there's the Florida Supreme Court, which is basically the only court in the state that has judicial power before delegating its authority to the inferior courts for the purpose of workload and efficiency. Henceforth, you can always escalate it as a final means at state level on the Supreme Court. But just as a side note, you can always do it at a nice state level, even after the state Supreme Court. So the question is, did searching JL solely on the basis of the anonymous tip received by the Miami-Dade police violate the Fourth Amendment right against a reasonable search and seizure? Conclusion: yes. Searching this 15-year-old solely based on anonymous tip received by the police department did in fact violate the Fourth Amendment. They go on to explain why. They said yes. In a unanimous opinion authorized by Justice Ruth Bader Ginsburg, the court concluded that JL, the anonymous tip, did not meet the minimum requirement to perform a warrantless search. So all that stuff people talk about in order for them to search or seize you, they get a warrant, probable cause. There is such a thing as a warrantless search, called a Terry stop. But there are standards and criteria to that. And one of the standards and criteria to that, beyond the explanation at the beginning of exactly what Terry stop is also what it's premised upon. Meaning something has to trigger it. It has to be a cause of action. Probable cause is relating to the requirement of warrant for search and seizure. Then there's this investigatory tool called a warrantless search, called a Terry stop, called a stop and frisk. Something else has to trigger that in and of its own. There has to be a cause for that also. And usually, in this subject matter, what usually triggers that arbitrary warrantless search, aka Terry stop, is usually because someone snitched on you. So now they're asking, well, someone snitched on this guy that he was doing one thing or the other. We're not even going to look at whether that's right or wrong, whether him bearing a firearm is right or wrong, whether him transporting, carrying, or using is right or wrong. The premise itself is what they're looking at. They got an anonymous tip, and solely based on that anonymous tip, was it sufficient for them to use that anonymous tip to search this 15-year-old or not? If it's sufficient to use that anonymous tip, that means it is constitutional and it does not violate the Fourth Amendment. If it's not sufficient, the anonymous tip. If the anonymous tip is not sufficient to search and seize this man, then it's unconstitutional. The anonymous tip did not meet the minimum requirement to perform a warrantless search. In other words, a Terry stop has a requirement, and an anonymous tip is not one of those. Again, 9 out of 10 times when these municipal security armed men or women appear in a situation, it is because someone has deliberately summoned them based on them saying, hey, something is going on over here, show up. Anonymous tip. And usually the dispatcher that's contracting with the municipalities that has that security company called the police department, that dispatcher usually asks, what is your name? It's your option to leave your name or not. Usually most people will not leave their names, hence an anonymous tip, as shown in this instance, and usually in many more instances. Someone who is brave enough to dial 911 is usually not brave enough to leave their name, because you can always obtain those information and either sue them for disorderly conduct or some other things, or find them in, well, someone who wants to get you in a situation where they potentially know that it could destroy your life. They don't want any type of karma coming back to them. Some people take things to their own hands. Therefore, most snitches are smart enough to say, no, I don't want to leave my name, hence an anonymous tip. Makes sense, right? Okay. The anonymous tip did not meet the minimum requirement to perform a warrantless search. Justice Ginsburg, drawing from the court's logic in Terry versus Ohio, which this case law is the origin of what's called an investigatory stop, aka a Terry stop, aka stop and frisk, aka the warrantless search, and Adams versus Williams, indicated that an anonymous tip must possess a moderate level of reliability. In the past, we've done another video regarding indicia of reliability. Go watch that. But it's more so specific to the interaction of bar members trying to say your document has no merit. But the same concept applies when it comes to other corporate actors, including predictive information, aka the anticipation that a crime is about to take place, or that a crime took place, or the crime is currently taking place. Those are the elements of a Terry stop. That offers police a, quote, means to test the informant's knowledge or credibility, the informant being the anonymous tip. If the anonymous tip is that, hey, this guy has a firearm, come check it out. The predictive information now that the municipal armed man has as an onus is to figure out whether that tip contributes to a past event of a crime, a current one taking place, or an anticipated one in the future. That's basically what all this is saying. It goes on to say an accurate description of a person without a reliable assertion of illegal or description of the crime in question, as was the anonymous tip in this case, does not meet this standard. Merely describing what someone looks like and that they have a firearm is insufficient to determine whether a past crime occurred regarding that same description of that man and what they're holding. And said description of what they are and what they're holding, if it does not corroborate with an ongoing or anticipated crime, then it is insufficient to trigger a Terry stop. In so many more words, whenever someone snitches on another man to summon some cops, for those cops to be able to search you by saying, hey, we're just going to do a Terry stop without a warrant, they have to have a reasonable articulable suspicion that a crime took place, is taking place, or is about to take place, based on what was told to them. Your mere description, or the mere description of what you have on, what you look like, or what you're currently carrying with you, is insufficient to trigger a Terry stop. A crime still has to be involved, because the whole purpose of a Terry stop is to investigate a crime so that they could circumvent the requirement for a warrant, as required by the probable cause standard in the Fourth Amendment. So now, if we do an investigation of a crime and we do find it, then we can say there's an exigent circumstance, aka an emergency. So now we don't have to now go through the whole rigmarole of getting a warrant, because, well, this guy might get away, so we can just quickly apprehend him. Why? For the purpose of public safety. That's the logic behind Terry stop. But even then, merely being told by some random man or woman who you don't even know what their state of mind or their motive is, and the entropy of information from that man or woman to the dispatcher, and then from the dispatcher to the cops going out there, if it does not involve the anticipation of a future crime or an active crime taking place or a recently committed crime related to that anonymous tip, then it does not trigger a Terry stop. Then goes on to say, quote, all the police had to go on in this case was the bare report of an unknown, unaccountable informant who neither explained how he knew about the gun nor supplied him the basis for belief he had inside information. Simple as that. Again, did search in jail solely on the basis of the anonymous tip received by the Miami-Dade police violate his Fourth Amendment right against a reasonable search and seizure? Yes, it did. In order for a Terry stop to be properly triggered, it has to be tethered to the existence of a future, past, or present crime. In order for a stop and frisk, in order for an investigatory stop to be properly triggered, without the existence of a warrant, aka a warrantless search, it has to be tethered to an ongoing, future, or past crime. As they tell you here, an accurate description of a person without a reliable assertion of illegality or description of the crime in question does not meet the standard. A crime is required for given a Terry stop to exist. So long as there's an allegation of a crime and it can be properly corroborated past, present, or future, then what they're saying effectively here is that a warrantless search can be enforced. Just keep that in mind. As much as this might sound good, you hear, oh yeah, it violates the Fourth Amendment, but the premise that they're dealing with is, did that anonymous tip mention anything about a crime? No, they didn't. All they did was just describe someone with a firearm. The mere possession of a firearm itself is not a crime. Henceforth, that evidence had to be suppressed. And the conclusion was that it violated its Fourth Amendment. Now, had that existence of the possession of the firearm was tethered to a claim of a crime, then the case would have been different. In summary, the Terry stop requires the existence of a crime to be attached to it. And the Terry stop is attached to the investigation and possession of firearm. And it has to be brief, it has to be on the outer layer, as we've run over in other videos. Until next time, take care. Best of luck. Beautiful people, I'm inviting you to join my Patreon page. The things we speak of over there are basically synonymous with webinars, each videos, when it comes to the quality of information and the actual aspect of it compared to the one here on YouTube. We speak about residual income and how to sue people, make residual income if you're willing to do that. We speak about tort and garnishment, remove the speculations of maritime lien. We speak about banking, express trust, all the intricacies that are important. We speak about trust-related matters, different types of trust, how to actually function in commerce. We speak about the intricacies of how to actually do the W-8 ban and what makes it foreign, what tax treaties are, the stuff people won't tell you about. We speak about things of spiritual nature. We speak of child support, the intricacies of it, how it's all property right, and how cloud of legality is brought to life. Exactly how they do it and how you tackle that beyond speculation. We speak about how laws are made and how it's applicable or not, the intricacies according to the Constitution. We speak about the truth of what most people are fearful and speculative about. We go over the elements of the things that people need to know when they make claims to sue people to make money, either criminally or civil. When it comes to substantive right, we speak about the venue and the playing field that a lot of people don't know that they're stepping into. If you don't know the venue and the playing field you're stepping into, you're in for a world of hurt. We clarify misconceptions. We speak about the intricacies of things we speak here on YouTube, but more in details on Patreon. Basically, stuff that are on YouTube are synonymous with things that are for the birds. One on the Patreon are the premium quality things. In the past, we went over IRS manuals in different ways. When it comes to the Express Trust 98 number, we went over the intricacies of mortgage, land, title. We went over issues with things like driver's license and the treaties that are the solutions for it, based on examples of my own first-hand knowledge and experience. Speaking about trust-related matters, more on child-related issues. We discuss other aspects of things. We discuss how to really come in as a natural person and the fact that there are actually tools that pre-exist that are meant to be used. A lot of people say, well, don't use this, don't use that. Well, do you know that same thing you're running away from is actually the solution? And do you know that's one of the ways and your first step to actually garnish it? We speak about the intricate details of discharge. We speak about things of reality that goes over people's heads. More on discharge, we speak about the functionality of spirituality and cosmology and astrology and how you can actually put it to use. We speak of the what, why, and how and importance of a foreign trustee and the resident status. We speak about spiritual things when it comes to plant, the functional aspect of it. We speak of the language of the difference in the truth of legislative fact compared to adjudicated fact and what it really means when it comes to judicial notice. We speak about the lunar mansions, how to put them to use. We speak about tort, U.S. Marshal Service. We upload documents and treaties, original certified copies. Tax evasion. We show the IRS manual that shows the difference between tax evasion and tax avoidance. We go more in about how to actually make your own pocket bigger in commerce. We show the videos and experience that I have when it comes to discharge and the explanation of it. We show elements and details. We speak of the things relating to holding people liable. Speak about the different intricacies of how these entities are used against you and how you ought to use it, and to know the playing field. A lot more that a lot of people are seeking but will not find. Again, each of these videos are synonymous to webinars of their own. We speak about how to get rid of statute of limitation. Most people's remedies, they say, are barred by statute of limitation, but there's a way out to that. We speak about how child supports are private and how and why they want to charge you thousands of dollars for some transcript, how to nip that in the butt, and a different aspect of it in great details and in great increments. Speak about the intricacies of fraud, how to prove it, the different types and the elements to it. Speak about tort. Speak about speak about trust. Speak about the subtleties of invoking equity and how to structure your document, and so on and so forth. Speak about private right, the incorporation doctrine, how people use UCC 1-103207-308, how that really doesn't actually preserve your right, contrary to the speculation that a lot of people throw around, and that your solution is actually in plain sight beyond the volatile and immutable UCC, which, by the way, the UCCs are also copyrighted. We speak about spiritual things of nature and how to use flame, and the functional aspect of beyond make-believe. I show my own first-hand experience in Chancery Court, and so on and so forth, and a lot more to come. Till next time, take care. Best of luck.